and it's a Q&A. But I just think it's something that I probably should have addressed a little bit more. I don't want to say demonstratively the last time, but it was something that I believe I probably should have been a little bit more ardent about when I was discussing it when I was walking away, because I'm still
Oh,
getting these phone calls, and we still got these people on here who think things work that just do not work.
by the way, I think while we were talking maybe a week ago or so, you did say something about the COL letter that you were gonna talk about too as well. I don't know if you had that on the agenda for the day.
COL.
The color of law,
Oh,
template.
ah, color of law just means that the people who are doing it are cloaked with the authority of the state. That's all COL means. It's not fancy. It just is what it again, it is what it is. And I'm wondering why I can't get this thing to make me smaller now. But I can't seem to move my YouTube screen. But I get it figured out eventually. But when you say color of law, what specifically about the issue of color of law did you want me to address? So that way I'll make sure I'm not missing something that maybe might be beneficial to somebody.
I think one of the things is the package boys, the way they use it is a way to kind of hold state actors in saying that, they can't do this once you present that. Where
Oh,
where is it in fact that if it is something to that level where they do cause damages, one, you would have to prove it first and then
right.
seek damages, as opposed to, no, you can't put me on child support because I filed the COL letter. Or you
Yeah,
can or you can't suspend my license because I
yeah.
filed a
Let me
COL
let
letter.
me do it. Oh, I know what you're talking about. The dear colleague letter.
Oh yeah, that's part of it. Yeah, that's part
The
of that
dear
too. Yeah,
colleague letter. Yes,
correct.
yes, 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 yes.
Yeah.
Let's do that. That's definitely something that unfortunately a lot of people have taken this just weird approach to thinking that the dear colleague letter prevents them from suspending a license. The dear colleague letter doesn't even speak to that issue. Not in that context. Essentially, the dear colleague letter tells them to do what they're supposed to do anyway, which was operate by giving you either an immediate pre-deprivation hearing or an immediate post-deprivation hearing before taking your license. That's it. And in most instances, that happens. If it doesn't happen, you may have a recourse, but it doesn't mean that the process isn't going to take its course. And I go back to when I started learning some of this stuff, and I'll tell you guys, I was and I'm it's funny. Only now it's only funny because I have the results that I have now, thank God. But that a lot of this stuff we've already tried it. Even Jimmy told you all, if Will could come on now, he could tell you all, but I know he's working. We're around here thinking that this stuff is new, or these guys think they have some kind of holy grail, and you don't have a holy grail. You probably have more of an unholy grail when it comes to this information, to this stuff. And I'll tell you guys this one more time. Read it for what's there. But to your issue about suing somebody for something under color of law, yes, you had to get your relief first. In 99.9% of the cases, especially trying to get some sort of monetary damages. And in most, from what I'm seeing with a lot of guys, I'll be honest with you, you don't have a claim.